Thank you. Thank you, and welcome back. This part 2 is going to be about causation and issues of proof in tort trials. So, in the United States, our doctrine on causation divides causation into 2 parts. The first is called cause in fact, and the second is called proximate cause. So I'm going to talk first about cause in fact, second proximate cause. Proximate cause is known as legal causation or scope of liability. But first, for cause in fact, the idea is that you have to find some empirical, factual substrate that connects the breach of a duty of care with the ultimate harm. Importantly here, we bring up the subject of evidence because our standard that the plaintiff has to meet is preponderance of the evidence. And what statistically preponderance of the evidence means is that it's more likely than not that the defendant's breach of the duty of care caused the particular harm. So if we translate this into mathematical terms, that would be more than 50% chance, means more likely than not. And the way we think about it is a kind of counterfactual. Absent the defendant's conduct that was negligent or failed to meet the standard of care, the harm would not have occurred. Now, of course, right away we run up against the largest barrier in establishing causation, which is evidential and scientific uncertainty. And there are different forms of this. Sometimes there is evidence, but the plaintiff will be at a disadvantage in terms of discovering that evidence, being able to bring it forward to satisfy the burden of proof. Sometimes it's not a matter of the evidence and the facts are out there. It's actually that there's true scientific uncertainty. And so what's interesting is that the party upon whom you place the burden of proof, and Raphael spoke a lot about how here the controversies seem to focus singularly on who has the burden and less about the underlying facts. But in these kinds of instances, courts have devised various theories. So these are deviations from the standard preponderance of the evidence. In other words, deviations that say the plaintiff can satisfy its burden to establish causation with something less than showing enough factual evidence to show that it's more likely than not that the defendant's conduct caused the harm. I'm going to talk about several of these theories, but we start with what's known as the substantial factor test. The substantial factor test is used by courts to show when there are multiple sufficient causes. So if more than one defendant or more than one entity caused the harm, you wouldn't be able to say as to any one of them, but for that defendant's action, the harm would not have occurred. It's sort of overdetermined harms. So in those instances, instead of using the but-for standard of the preponderance of the evidence, courts will use this substantial factor. So this one's more controversial. I alluded to this earlier when I was asked a question about how plaintiffs can establish causation in medical malpractice cases. And I alluded to this theory called the strong causal link rule. I'm going to come back to talk about it some more, but this was a theory that was put forth by Judge Calabresi in a case called Zuckowitz. It's going to be a case example that I come to, and I'll talk through the example. But what he basically put forward is that in certain instances where the plaintiff can't establish but-for causation by the preponderance standard, as long as they can establish what he calls a strong causal link, in certain circumstances, the burden would then shift to the defendant to come forward and disprove causation. So that is a more radical shifting of the burden of proof. And again, I'm going to come back to that. There's a theory known as alternative liability. This is a causation theory that applies when you have two actors, and the idea is either actor A or actor B caused the harm. You know for sure it was one of those. There's a classic case called Summers versus Tice, where two individuals were shooting. They were quail hunting, and the bullet pierced the eye of the plaintiff. The plaintiff couldn't determine whether the bullet came from person one or person two, but the idea was that A or B caused that harm, and alternative liability means that once the plaintiff has established that, then the burden is on the defendants, A or B, to come forward to disprove their own responsibility or to disprove causation. Finally, we have a theory called market share liability. This too is a kind of controversial extension of a causation theory. It was first formulated in the context of the DES drugs, which were manufactured by numerous manufacturers, drug manufacturers, all of whom were making substantially similar pills that couldn't be distinguished. So plaintiffs who had taken these and ended up having babies with various deformities were able to sue the manufacturers on what was known as the market share theory. So each of the manufacturers sued, produced this fungible product. It was a fungible product that the plaintiff was, through no fault of her own, not able to trace to a single defendant. And so market share liability allowed the defendant to sue the group of defendants, and each one was liable in proportion to its market share, right? How much of the market share of this drug each of the defendants had produced. Very controversial theory, and in fact there's a divide in jurisdictions as to whether on this theory of market share a single defendant can bring forward exculpatory evidence to say, I didn't make the pill that harmed this particular individual. In New York, in an extension of this original case called Heimowitz, the court decided that because market share liability is based on a broader theory of each of the defendants having exposed individual to a particular level of risk, they would not allow in an individual case this kind of exculpatory evidence. Importantly, in market share liability, you have all sorts of questions like, are you deciding this is a nationwide market or is it a more local jurisdiction? How are you going to figure out these particular shares? So what was interesting is this theory that, as I said, arose in a case called Sindel versus Abbott Labs over the DES drug. Some jurisdictions tried to use this to expand to other industries. So in the United States, there were plaintiffs' attorneys who brought lawsuits against lead paint manufacturers where they weren't able to identify which of the manufacturers had made the specific lead paint at issue, and jurisdictions were split, actually, as to whether or not you should extend this kind of market share liability outside of the limited domain of DES drugs. By and large, market share liability has been limited to either the DES cases themselves or to instances where the product is truly fungible. So for example, in many of the lead paint cases, the courts would say, well, lead paint isn't really fungible. It has different levels of different chemicals, et cetera, and so it's not right to put all of the defendants together and then allocate causation based on market share. But the theory here was a way to allow plaintiffs who would otherwise lose because they couldn't determine with factual evidence that a specific manufacturer more likely than not manufactured the particular pill that had caused injury. Then there is the loss of chance of survival. We heard yesterday about developments in Brazil and loss of chance, and I'm going to talk some more. I'm going to highlight that theory this evening and talk about a seminal case called Herskovits, which was the first major case in the United States in the early 80s that used this theory, and then I'm going to talk about its potential extension. So loss of chance is this idea that, as we heard yesterday, that courts will recognize a lost opportunity for cure. In this instance, I'm going to talk about medical malpractice. So it's a loss of opportunity for cure of a medical condition, and that lost opportunity itself is the cognizable legal harm. Now, what was interesting, and maybe in discussion we can talk some more about loss of chance as applied to medical malpractice here in Brazil, because in the United States, loss of chance has been applied almost exclusively to medical malpractice cases. There have been some jurisdictions that have suggested its extension into other areas, like loss of chance in a contest. Yesterday we were hearing about potential loss of chance with respect to Neymar's injury in the soccer match, etc. But in the United States, this is a theory that has been applied, and it's accepted in most jurisdictions, but not all. There's some resistance to this doctrine. I'm going to talk about that in a minute. But the primary application is in medical malpractice cases. And the idea is that if we were to use the preponderance of the evidence standard, the 51% or more than 50% chance that the doctor's negligence caused this harm, then it's going to exclude cases in which an individual, let's say, comes in who has a disease such that it's not, so that his likely survival before he even goes in to see the doctor is less than 50%. And the idea would be that in those situations, if you held the plaintiff to a more than 50% standard, then you would be denying claims for any individuals who's had less than 50% of a chance of survival to begin with. So take, for example, medical diagnosis of cancer, right? It matters very much at what point in time you're diagnosed. So if there's a misdiagnosis due to a doctor's negligence at time t=0, but that plaintiff, right, had perhaps, because it was a terminal type of cancer, less than 50% chance to survive, but had, say, 40% chance to survive, and as a result of the misdiagnosis, several months or years later, has only a 10% chance to survive now. The idea is, can we recognize the loss of the opportunity, the loss of the chance of survival, even when it's a less than 50% reduction? So, in other words, this lost opportunity can be thought of if you think of the difference between the ex ante probability, right, before any action by the doctor, of the outcome in light of the defendant's negligence, and then think about that as compared to the probability of the outcome absent defendant's negligence, right? So there is a reduction, in my hypothetical, in the patient's chance of survival that's due to the doctor's negligence, but it's not more likely than not that the doctor's negligence caused the death. So again, most jurisdictions have been persuaded that loss of chance is important because if a patient enters medical treatment with less than a 50% recovery, the patient won't be able to prove cause and fact by a preponderance of the evidence, no matter how glaring the doctor's negligence. So again, if we looked at this based on underlying theories of tort law, we would be very worried that absent any kind of recovery for loss of chance, doctors would be under-deterred, right? If one of the goals of tort law, as I was explaining earlier this morning, is a deterrence goal, trying to lead doctors to take the optimal level of care, the idea is they would have no incentive, at least no incentive based upon the threat of future lawsuits, to take care in situations where a patient has less than a 50% chance of survival. And again, I will come back to loss of chance when I discuss the Herskovits case. After we talk about cause and fact, which interestingly, right, sometimes when we teach tort law in the United States, cause and fact or factual causation seems like the least controversial of the factual elements, because proximate cause, which is known as legal causation or scope of liability, seems like a more difficult doctrine to understand, namely why in certain instances when you can prove a factual link between the defendant's conduct and the harm, why would the doctrine of law cut off legal liability? So this doctrine, proximate cause or scope of liability, has to do with instances where even though you could trace some line factually from the defendant's conduct to the harm, you would nonetheless not find causation unless in addition you can establish proximate or legal causation. So again, this is the link. You have to find a link between the defendant's conduct, even if it was a cause in fact. The notion of proximate cause is that the injury can be too remote, too attenuated. There are two basic tests that jurisdictions use to establish proximate causation. The first one is called the directness test. This is what we call a backward-looking test. Basically, to understand this, if I had a chalkboard or could draw up here, I would write T equals 0. T equals 0 is the time at which the defendant takes an action, and T equals 1 down the road is the time at which the plaintiff is injured, okay? So the backward-looking test says you start at T equals 1. You start at the point in time where plaintiff has suffered an injury, and you look backwards to T equals 0 and ask the question whether anything breaks the chain of causation. In other words, there's a chain of causation that has been established by cause and fact, but it might be that notwithstanding that, there have been intervening breaks in that chain of causation. Those could be from third parties. They could be natural events, you might say God or natural events intervening, or they could be actions by the plaintiff, him or herself. So all of those things could cut off the chain of causation leading from T equals 0 to T equals 1. And it's a backward-looking test that looks back after the time the plaintiff is injured and asks if there's been any kind of intervening break in that chain. The foresight test, by contrast, is a forward-looking test, and it attempts to start at T equals 0, start at the time when the defendant acted, and ask at that time, what were the foreseeable harms? What were the foreseeable harms that could arise from the type of risk that the defendant exposed the plaintiff or anyone in the community actually to by his or her conduct? And what you ask is you then decide, you say, what are the foreseeable harms? And you look then at the injury that happened at T equals 1, and you ask, was that within the scope of the foreseeable harms? Now, actually, most jurisdictions in the United States apply a kind of combination of both the directness test and the foresight test, and they're not very clear about what they're doing. Proximate cause has been called lots of negative things by scholars and by judges in the United States, that it's a kind of policy limitation on liability that doesn't really have any kind of basis. There's been a lot of criticism even about the use of the words proximate cause. The restatement has tried in the third restatement to use a new term. They try to use scope of liability because they say that proximate cause is such a nebulous concept, and scope of liability, meaning is the risk that is the harm that occurred to the plaintiff within the scope of the risks that the defendant's conduct was deemed to be negligent because it was exposing the plaintiff to those types of risks, is seen to be kind of a better approach. But I think it's helpful conceptually, at least, to separate out these two prongs or ways to establish proximate or legal causation. Another issue that we come to in looking at causation and issues of proof is this fundamental issue of admissibility of evidence, and in particular, admissibility of expert evidence. There's a little cartoon down here that's a little bit hard to read, but this magician here, who is the attorney trying to convince the judge, says, ta-da, this is an expert, right? Ta-da, here's my opinion, i.e. the opinion's just coming out of the hat, isn't being scientifically validated. And the judge says, Dalbert, which is an important case that I'll talk about in a minute, liberalized the standard for the admission of expert opinions, but that doesn't mean you can pull your opinion out of thin air. Okay, so this gives you an idea of the controversy that we've seen in the United States between this new standard, relatively new. The Dalbert standard came into play. The U.S. Supreme Court issued this opinion, Dalbert. So technically, it was an opinion about the federal rules of evidence, although states very much look to the federal rules of evidence when they're deciding their own admissibility decisions. So the standard was that testimony of experts would be admissible if relevant and reliable, based on sound scientific methodology and consideration of relevant factors supporting admission. And what this was contrasted with was the earlier Frye standard. Under the Frye standard, expert testimony was admissible only if it was corroborated by general scientific consensus. So what this cartoon is trying to show is that Dalbert certainly liberalized the Frye standard. The Frye standard was seen as a more stringent standard because it had to be corroborated by general scientific consensus. You had to have scientific expert testimony that was validating that this was the consensus view, whereas Dalbert allows a softer standard. It has to be based on sound scientific methodology, but the judge is given more leeway to admit testimony by experts under this standard. So when you compare the Dalbert standard to the Frye standard, the criticisms of Frye were that it improperly deferred to scientists what were legal questions of admissibility, of evidence. In other words, Frye, because it was dependent on a general scientific consensus, left to the scientists this question of what should be deemed relevant as a legal matter in a legal dispute. The Dalbert standard, however, is criticized because it takes from scientists and confers upon the judge, who are allegedly uneducated in science, or at least that's not their primary training, and it gives them the authority to determine what is scientific, right? Now, the cartoon, of course, is trying to show that there are nonetheless limits, right? A judge isn't going to let everything in. An expert can't just pull an opinion out of his hat. He has to show that it's relevant and reliable and also based on some kind of sound scientific methodology. But he doesn't have to establish this idea that it's backed by a general scientific consensus. So it does give the judge more of a gatekeeping role in terms of deciding what kind of expert evidence is admitted. Now, I alluded to this earlier this morning too. Very important in medical malpractice cases to consider the use of experts. So experts are almost always required in medical malpractice cases to determine whether or not the physician breached the professional standard of care. So in negligence cases, right, we have to establish breach of a duty of reasonable care, and then causation, and then damages. So experts are almost always required on the breach of the duty of care to come in and establish what the national professional standard is. And they're frequently, but not always, and we'll get to this debate, required to establish causation. So it's also, by the way, used in an offshoot of medical malpractice cases, which are informed consent, right? Informed consent cases are based on negligence, and the idea is that the doctor didn't give sufficient information to the patient to make an informed choice as to whether to undertake certain procedures or not. So what's interesting, and this is what I started to discuss in response to a question this morning, is almost every state has an exception, namely there's no need for medical expert testimony on causation when the malpractice is so obvious that experts aren't needed. And there's this rule that's called res ipsa loquitur, or the thing speaks for itself. And this rule, it's an evidentiary rule, but it's very powerful in terms of establishing negligence, is that first, only the doctor or the medical staff had control over whatever it was that caused the injury. And secondly, this notion that the injury could only have been caused by the doctors failing to adhere to a normal standard of care. So this morning I told you the seminal case that established this use of res ipsa in medical malpractice is called Ibarra versus Spangard. It was a case that arose when an individual had appendicitis and was in the hospital to get an appendectomy, to have his appendix removed. While he was unconscious, he was treated by several different physicians and nurses. When he awoke from an anesthesiologist, when he awoke from the surgery, he had intense pain in his neck and his shoulder. So he was worried that something negligent had happened to him, that maybe he was pushed off the operating table or something like that. And he brought suit against 5 different defendants, the different doctors and nurses, and the defendants tried to say he can't show causation. He hasn't been able to point to any specific evidence that anyone in the room, any of the doctors or nurses, breached any duty of care that caused this injury. And what the court did is they said that the doctrine of res ipsa loquitur the plaintiff should be able to use that. So in other words, in this instance, the plaintiff should be able to say, well, I was unconscious and in the sole care of these doctors and nurses, right? That's the first prong, that only the doctor or the medical staff had control over whatever it was that caused the injury. And the court was persuaded that given his circumstances, namely both that he was unconscious at the time and couldn't have directly witnessed any of the doctors or nurses' activities, but also that the court was worried about what it called a conspiracy of silence on the part of the doctors and medical communities. The court was skeptical. They thought one of the doctors maybe, had witnessed or would be able to testify as to what happened, but wouldn't come forward voluntarily because of a conspiracy of silence. So what the court said is that in this kind of instance where the plaintiff is unable to show the negligence on the part of the doctors or nurses through no fault of his own, and has an injury that the court said had to have been caused by some kind of negligence, in those instances, the court used res ipsa, allowed the plaintiff, who couldn't otherwise establish by preponderance of the evidence that anyone had been negligent toward him, used res ipsa as a way to force information out. As I mentioned earlier this morning, we call this the information forcing effect of using res ipsa. It didn't shift the burden entirely to the defendants, to the doctors, or to the nurses to disprove causation, but the court was very clear that the plaintiff had alleged enough such that the defendants now had a burden of an initial explanation. The defendants had to come forward and tell their story as to how they thought that either their actions could not possibly have led to this outcome, or if in fact they had seen something. So it was used as a tool to force the defendants out of their silence, right? In other words, the defendants couldn't just stay silent because the court said the plaintiff said enough to switch this burden of producing information over to the defendants. Now, there are still some situations in which courts today in the United States hold that an expert isn't necessarily required. But res ipsa is quite controversial because some jurisdictions in the states think that doctrine's gone too far, and therefore they've established rules. About 30 states in the United States require expert medical testimony. And many of them say, even though plaintiffs can use this doctrine of res ipsa, that it can only be used in very limited circumstances. The paradigmatic situation is where an instrument is found after a surgery still in the body, right, of the patient. In those circumstances, courts are generally going to find you don't need medical expert testimony. This could not have happened absent some kind of negligence, and you can sue all of the parties that in whose care the patient was. All right, lots of current issues in the United States over the use of experts in medical malpractice cases. There is a rife industry of doctors, physicians who serve as experts in trial, and there's skepticism as to whether or not these medical experts are more than just, say, hired guns on the part of the competing attorneys, and some wariness. So states have added various restrictions. So 30 states have various restrictions on who's allowed to serve as a medical expert. Some of these restrictions have to do with the doctor has to be certified, board certified in the area of specialty of that's at issue in the case. Some states say that these doctors have to practice only in that state. You can't be, there were sort of some go-to medical experts. So if you were in New Jersey, you couldn't go to your go-to expert from Alabama and import him into that practice. There are other restrictions. Some states say that no physician can testify who doesn't also have a clinical practice and spend at least 60% of his or her time in clinical practice. Again, the worry was they didn't want medical experts who were physicians who no longer practiced medicine. They just came and testified at legal trials. So there are various restrictions that states have enacted. There are other types of reforms. I'm just giving you a few examples. So Texas, for example, became very stringent on these requirements in medical malpractice cases, require that an expert report is filed in every case that a plaintiff is alleging medical malpractice. So they file the complaint, they're going to want to try to go to trial, and they have to submit their medical expert's report showing that there really was medical malpractice, some kind of negligence in the case. But Texas has this procedural process where they allow the defendant, very much at the outset, when the plaintiff has just submitted their initial report before any answer is filed by the defendant, before it goes to trial, before any of the facts are fleshed out. They allow the defendants to file an appeal right away challenging the expert's report. In other words, it's a measure to try to remove these cases from court. Earlier this morning, too, I was asked a question, I know, about frivolous lawsuits. So this is a reform, a fairly stringent reform, that was enacted by Texas on the theory that even a plaintiff who has medical expert testimony and has filed a report to substantiate the claim that they want to go to trial to prove, the defendants can file an appeal and say it's not good enough, and they can do that at the outset of the case. There's also a process of professional discipline. There's been some research done by Charlie Silver, who's at the University of Texas, looking at this, showing that physicians have actually increasingly started to use professional discipline to go after physicians that will testify on behalf of plaintiffs, right? So it's a different form. It's not a conspiracy of silence per se, but it's an increase in actions brought by physicians against colleagues who are testifying on behalf of plaintiffs, and they're bringing disciplinary actions within the medical community. And the final and probably most important doctrinally have been challenges to the use of this doctrine, res ipsa loquitur. And this is very important because the decision whether what's known as the common knowledge rule, right, whether you can use res ipsa to say this wouldn't have happened absent some kind of negligence on the part of the doctors, often determines the outcome of negligence claims against healthcare providers. Why is that? Well, getting medical expert testimony is very costly. It can be fought very vigorously. So in some instances, if the plaintiff isn't able to use res ipsa and is in a state that restricts the use of res ipsa to, say, cases where a medical instrument is left within you after operation, then it's going to very dramatically affect the number of medical malpractice cases, leading to a decrease in those cases. Okay, I mentioned I wanted to give you some case studies. So the first one I want to talk about, this is the case Zuckowitz versus United States. This is a very important decision that was rendered by Guido Calabresi. I mentioned him earlier in my lecture. He is a seminal figure in U.S. tort law. In 1970, he was a law professor at Yale, and he taught tort law. He wrote a book called The Cost of Accidents that was very was provocative at the time, and it became the basis for a whole movement about bringing in economic analysis into law. And after he was a law professor at Yale, he was the dean of Yale Law School, and then he was appointed by President Clinton to the Federal Court of Appeals. This is the federal appellate court that decides appeals from the district court or trial level, and the Second Circuit covers New York, Connecticut, New Hampshire, Vermont. So that's the sort of jurisdiction of the court. And in this case, just a bit about the facts to understand this case a little better. Patricia Zuckowitz had been given a prescription for a drug called Danacrin. This was at a naval hospital, and the prescription, when it was filled, the instructions were erroneous. They actually instructed her to take 2 times the recommended dosage. So the defendant, and actually the defendant is the United States here because this happened on a naval base. This is important in this case for the reason that I went over earlier this morning. Almost all tort cases, I told you, are before juries. The exception is when you sue the United States, it's under a federal statute called the Federal Tort Claims Act, and those cases go just before a judge. So this is a case that was tried before a district court judge and then was appealed up to the Second Circuit. So the defendant in this case conceded that the doctors and or the pharmacists were negligent. They knew that the dosage was supposed to be, I think it was 800 grams, and instead it had been prescribed or written in the instructions to be 1,600. So it was double the dosage, and that was an error. And no one tried to contest that error. What happened is the plaintiff was diagnosed with what we'll call PPH. It's primary pulmonary hypertension. But so I don't get tripped up saying that too many times. PPH is her disease. And this was a fatal lung condition. And this woman died. And then her husband brought forward the lawsuit. Now, two things are really important to understanding this case. And I think it's a good case example for us tonight. One is the role of expert testimony. And then the second is the theory of causation. This is the case where Judge Calabresi came up with a theory known as the strong causal link. But first, the expert testimony. The plaintiff's expert, before the district court judge, had testified that the overdose caused PPH. However, most of his testimony was actually just about the scientific link between taking Danacrine and getting this condition. In other words, not just the overdose, right? The very fact that you're taking this drug could lead to the condition. And that was scientifically validated. He showed his studies, etc. It was only when he was pressed by the plaintiff's attorney, well, don't you mean that the overdose can lead to PPH, not just the drug? He said yes, and his conclusion was based on the temporal relationship between her taking the drug at the 2 times the prescribed limit and when the disease was diagnosed. In other words, he didn't present scientific studies, validation that showed an overdose leads to PPH. He talked about how the drug itself could lead to that, and then when pressed, he said, yes, I think the overdose could lead to it. Why do I say that? Well, her disease started shortly in time after she started taking twice the limit of the drug. He also excluded some other possible causes, but basically what he did is he excluded other causes that were other drug-induced causes of the PPH. The bottom line, the reason I'm going over this in some detail, is that there was a big dispute as to whether or not there was enough factual scientific evidence put forward linking the overdose, namely the negligence in the case, with the condition. The federal district court accepted this expert testimony under the Daubert standard. Right? The defense tried to argue that there was nothing linking the overdose to PPH that was based on certainly not general scientific consensus, which would have been the standard under Frye. And under this liberalized Daubert standard, the defendant said, this isn't good enough. It's not good enough that this expert just opined based on the temporal relationship. That shouldn't have sufficed. But the district court accepted the expert testimony. And you can see, one of the things I think that this case shows is how this admissibility of evidence can be dispositive in a case. If the court had not received this expert testimony, the plaintiff would have lost this case. They wouldn't have been able to establish causation, the cause in fact. So that is a very important juncture for a tort case. As I mentioned, there was an expert testimony dispute. The defendant was very vociferously argued that you need to do more than just show a temporal relationship. You need to show scientifically validated studies, and the plaintiff had not done that. The plaintiff said that, well, this is a conclusion of an expert, therefore it's within what Daubert calls the scientific method. It was arguably a close call, right? And it shows, in some sense, the district court's judge determination. The district court judge has a lot of discretion about what kind of evidence will be admitted or not. Secondly, there was on appeal a huge dispute over causation. The defendant argued that it shouldn't be held liable because the plaintiff hadn't proven that the overdose was a but-for cause of the harm. Namely, it could have been that just taking Danacrin over time was going to lead to this bad outcome. The judge, the Court of Appeals, but it was Judge Calabresi writing the opinion for the majority of the court. The court sits in panels of 3. So the judge conceded in the case that there was no but-for causation. Now, the typical paradigmatic tort then would say, therefore the plaintiff loses. They haven't shown, and it's the plaintiff's burden to show but-for causation. Here's where the court articulated a rule known as the strong causal link. So what was the strong causal link in this instance? This is a lot of text. I'll go through it though, right? So it was one, the negligent act is deemed wrongful because that act increased the chances that a particular accident would happen. And secondly, such a mishap did happen. And this would be enough to support a finding that the negligent behavior caused the harm. So what was the evidence in this case? Well, first of all, there was some testimony by the expert. But the court, you could see, the appellate court, was skeptical. Even though the expert evidence was let in, they were skeptical that the expert had done enough to establish but-for causation. There was some testimony, though, by a medical expert. The second thing the court looked to was the fact that this involved a prescription drug, and this is an area where we have the FDA, the Food and Drug Administration, specifically approves drugs in particular dosages for the very reason that they're worried that overdoses could lead to terrible adverse outcomes. And so what Judge Calabresi said in this opinion is, well, we can therefore infer that the negligence here, namely giving an overdose of the drug, is exactly the kind of risk that the FDA is involved in regulating to preclude bad medical outcomes. And so in this instance, because it falls within those parameters, he suggested that there was enough of a strong causal link. There was no but-for causation, but what happens is this strong causal link means that the plaintiff has done enough to switch the burden of proof onto the defendants, who then have to come forward to show that it was not the but-for cause. And in this case, right, given this fact that it's based on true scientific uncertainty, remember there were no competing scientific studies, the plaintiff didn't have any to rely on, and the defendant didn't have any to rely on. So in this case, the idea of shifting the burden of proof onto the defendant was dispositive, right? There was no, the defendant didn't have any kind of evidence to come forward to prove that it's not possible, right, or it's not more likely than not that the overdose led to the bad outcome. A very controversial ruling. This is Judge Calabresi down in the corner here. He was the first, as I said, to articulate. I should say, too, that in addition to Judge Calabresi having been a big influence to me intellectually, I also clerked for him as a law clerk right out of law school. So I worked on a variety of tort cases with him, including the Zuckowitz case, which was decided the year that I was clerking for Judge Calabresi. So the treatment of this strong causal link in other jurisdictions has been mixed. In other words, some jurisdictions have liked this rule and have deployed it, and others have said it's going too far and it relieves too much of the burden on plaintiffs. So they've resisted the doctrine. Just to give you a few examples of some positive examples, Two other federal courts of appeals, the Third Circuit and the Fourth Circuit, followed Zuckowitz in holding that medical testimony that's relying on this kind of temporal relationship is sufficient to establish causation. And I'll just switch over here to a couple negative examples, though, have said that the Daubert standard should be more firm, and it should exclude testimony that lacks a hard scientific corroboration, even if this testimony is based on clinical medical methodology. Even if the doctor were to say, in my experience, it's more likely than not that this condition was caused by the overdose. That's not enough. Okay. Second case study that I want to talk about this evening before we open things up for discussion is the loss of chance case that I alluded to earlier. It's called Herskovits versus Group Health Cooperative. It's from the Washington Supreme Court in 1983. So we've had, that's sort of the first case that established and applied loss of chance. We've now had several decades of experience with it. I should say that the bottom line is that the theory of loss of chance has become fairly widely accepted, but primarily in medical malpractice cases. Lots of resistance to extending that theory outside of that domain. So in this case, it is a medical malpractice case. Herskovits came to the hospital with complaints of pain and coughing. He was treated just with cough medicine. There was no further inquiry made by the hospital concerning his symptoms. He wasn't told, other than getting occasional chest x-rays, any kind of course of treatment that he should follow. He went to seek another medical opinion in a few years, and at that point he was diagnosed with cancer, and he ultimately died, and his wife brought the suit. So there was expert testimony on causation, but here the plaintiff was not able to use expert testimony to show that the delay in his diagnosis of cancer probably or more likely than not caused the death. In other words, the cancer itself would have caused the death, and they were unable to point out to the time and delay itself having caused the death. However, the plaintiff's expert was able to put forward figures, statistics that showed specifically that the delay in diagnosis had reduced his chance of 5-year survival, and there are reams of these kinds of statistics, particularly with respect to cancer and 5-year survival rates. So his 5-year survival rate, based on the delay in diagnosis, went from 39% to 25%. So in other words, had he been correctly diagnosed at time t equals 0, he had a 39% chance of surviving for 5 years. Because of the negligent delay in the diagnosis, he had a 25% chance of survival. In other words, his chance of a 5-year survival decreased by 14 percentage points, right? From 39 to 25. It's interesting, the courts in the United States, while they've been favorably disposed towards a loss of chance in cases like this, as I mentioned, the alternative is to say that anyone who starts with less than a 50% chance of survival could never bring a medical malpractice case. That has been very persuasive to our jurisdictions. But when it comes to doing the math or figuring out what kind of damages should be awarded, there are different approaches. They're a little bit all over the map. In this case, there are fights over whether this is a 14% reduction or if it's a 36% reduction, because 36% of the original 39% chance of survival is what was reduced. So you can see how there are different ways to characterize exactly what the reduction here has been. But the court held, in this case, that the medical testimony of a reduction of a chance of survival was sufficient to allow the issue of proximate cause to go to the jury, that they weren't going to hold the plaintiff to this 50%, more than 50% reduction standard that the preponderance standard would seem to require. The court, as I mentioned before, this court and numerous courts to follow, was persuaded that there would be very bad incentive-based effects. If you think about tort liability, incentivizing physicians to take care, that doctors would not be deterred in situations in which a patient had a probable chance of death before treatment, right? If we take seriously the notion that tort liability can affect the incentives to take care, the court was worried about what some scholars have called the recurring miss situation, right? If you never allow tort lawsuits or liability in these kinds of situations, and you don't think they'll even out in the end, right? Since the preponderance standard, right, we plaintiffs who might be able to show that there's a 40% chance that something the defendant did caused their harm, we say too bad, right? But the idea is that more likely than not, over time, we'll get things about right. Well, here, they were worried that there would be systematically a recurring miss, namely a population of patients who show up for treatment before doctors with a lower than 50% chance of survival. And if we want to give the doctors the right incentive to take care, we need to have some kind of liability in those situations. Now, the issue of damages is very difficult for courts in these cases. In this case, the court held that the economic damages would be awarded based only on damages that were caused by the premature death, like lost earnings and additional medical expenses that were coming by the likely premature death that was experienced by the plaintiff. And the defendant's percentage of damages for which he's liable is proportional, the court said, to the difference between the initial chance of survival and the resulting chance of survival. So the 14 percentage point reduction here. This approach to apportioning damages is controversial in light of the fact, of course, that doctors are going to be liable for 100% of the damages if they're shown to be 51% of the cause, right? If they're more likely than not to have caused injury in a particular medical malpractice case, let's imagine, just to make it seem like an issue, if they're only 51% likely to have caused the harm, they're going to be paying full damages. And so the idea is, if we're going to allow proportional damages for things that are less than 50%, while awarding full damages above that, the argument is this could lead to over-deterrence. It could lead to, on balance, doctors having to pay out more, because it's not as if we do probabilistic causation or probabilistic allocation of damages where it's more likely than not. Treatment of loss of chance in other jurisdictions. There's been some positive treatment. The Fourth and the Seventh Circuits have affirmed the loss of chance rule. Again, they noted the adverse incentive effects, namely the idea that doctors would not be incentivized to take adequate care if they were to adhere to strict preponderance of the evidence rule. Among states that do recognize loss of chance, there are differences as to how they calculate the damages in those cases. In some that are known as pure loss of chance, they will make the doctor liable for the full amount of damages. This is a minority of states. There are about 5 jurisdictions, and they hew to the idea that as long as it's a significant loss of chance of survival, then it should be treated akin to how we treat preponderance of the evidence, and full damages are awarded. There's the proportional approach, where the doctor's held liable only for the absolute percentage of the loss of chance that the patient suffers. So in the Herskovitz case, that would be a 14% reduction, and that's the amount of the damages that are given. And then there's the substantial possibility approach, where the plaintiff has to just show that there's some substantial possibility that the defendant's negligence caused his injury. There's been some negative reactions. The Sixth Circuit and the D.C. Circuit, two federal circuits, have declined to follow the loss of chance rule and have stuck to a strict preponderance of the evidence. So it's not taken foot everywhere, but it is, whoops, that's getting on to tomorrow's. Now, I wanted to add, and I started reflecting on this between last night's presentation on loss of chance in Brazil and my presentation today. I've talked exclusively about medical malpractice cases because that's where loss of chance has actually been applied in the United States. There have been some cases where parties have tried to extend the loss of chance theory to things having to do with loss of an opportunity to win a particular prize in a contest and the like. There have been some jurisdictions that have said we don't see any reason in theory why we wouldn't expand loss of chance. However, we would need to have very good data to validate these loss of chances. So I think what it comes down to is in the United States, the reason we see loss of chance where it is being applied is because there's reams of data, mortality tables, et cetera, 5-year survival rates. There's a lot of data that you can show precisely. For example, if you're diagnosed at time t equals 2 instead of time t equals 1, what your reduction in loss of chance of survival is. So we have, we have enough validated data to persuade courts that they wouldn't just be pulling numbers out of a hat, so to speak. And I think that probably explains why loss of chance is applied primarily in the medical malpractice area, but it by no means would limit, in theory, its extension elsewhere. I'd have to say, though, I'm somewhat skeptical because having read a lot of these medical malpractice loss of chance cases, I think courts would be wary about applying notions of probabilistic causation writ large, right, in tort law. But instead here, in the U.S. at least, the courts seem to be motivated by areas where the defendant's conduct can cause, negligent conduct can cause serious injury, and there would be what I referred to earlier as this recurrent miss problem, namely whole sets of individuals like plaintiffs who show up for medical care with less than 50% recovery, who would be shut out of recovery altogether. But importantly, I think the courts in our jurisdictions have been motivated by the incentive effects on the doctors and worrying about the lack of tort liability in situations that might lead doctors to take too little care. And I don't think jurisdictions are going to find themselves as motivated in situations where someone's just lost an opportunity to win in a contest, right? They're not going to be as worried, I would argue, that they need to impose liability on those actors to make sure they take care to set up the contest correctly. I mean, they might, and there's no reason kind of in theory why if you recognize a loss of opportunity as a cognizable harm, it couldn't be extended. But I think that there's a reason that goes beyond just the availability of data in medical malpractice that will probably ground this theory's application primarily in that realm. I think now I'd be ready to open things for discussion and or no, actually, right, I always do this. First, we break. Yeah, so first we have coffee and break, and then we will come back and in 15 minutes? Yeah, in 15 minutes we'll come back and discuss. Thank you.